Okay, let's get started. I think we're here on a motion to compel in the Samuel Cook versus Raul Garuda case. Tony, are you ready?
Yes, Judge.
Let's go on the record on DC 257034, Samuel Cook versus Raul Garuda. Counsel, make your appearances.
Alexandra Boone and Ryan Richmond from Miller Weisbrod Oleski for the plaintiffs.
Tim Robinson and Steve Honeycutt for the defendants, Rob Garuda.
All right, you guys may proceed.
Thank you, Judge. If you recall, you heard a Rule 91A motion on this case back in August. This case involves premium financed indexed universal life insurance policies sold by defendant Garuda. Our clients were unaware that these policies were not going to perform as represented until after learning that Mr. Garuda was under indictment and in fact going to federal prison for tax-related charges in early 2024. Mr. Garuda had made continuing representations that the policies would provide income to our clients in their retirement, but that was not the case. At some point, knowing that he was going to be going to jail, Mr. Garuda transferred his business on these policies to another defendant in the case, Shelley Tomash, who was his assistant for a number of years. She has produced about 1,000 pages of records in the case and did so a long time ago. She has since also provided us an affidavit that said that she has produced everything that Mr. Garuda gave her. But these are not all the relevant documents. There are a lot of other documents, emails, other things that have to exist. We know some of this because our clients have emails with him that have never been produced. So in late August, we issued some discovery to Mr. Garuda to try to obtain these materials. The day before they were due, Mr. Garuda's counsel reached out to us and asked for a 45-day extension, claiming that Mr. Garuda had had surgery and could not read to verify that we had all the documents. This was the first time we were hearing about any kind of surgery. I agreed to a brief extension, but not 45 days. The next day, when the discovery was due, we were met with objections and nothing else. We've been told that, again, Mr. Garuda has been out of pocket and unable to find documents, and also that he gave everything to Ms. Tomash. Even if he did pass on these documents to Ms. Tomash, that does not relieve him of his obligation to provide discovery responses to us. We know from Ms. Tomash, who has spoken with us, that there are other people that may have these documents, including Mr. Garuda's defense lawyer from his criminal proceedings and a woman who is essentially his administrative assistant. And I've passed that information on to Mr. Garuda's counsel as well, asking if he can request those materials from them. Again, we have not received anything. As an aside, we have settled with defendant Tomash. She had a very small wasting policy, and in an effort to try to recover something for our clients, we have settled with her. Although Mr. Garuda has not responded to this motion to compel, his counsel has filed a subpoena and a motion to compel against Shelley Tomash, trying to get documents from her. That is not ripe yet. And again, Mr. Garuda still has an obligation to provide discovery in this case regardless. So that's why we're here.
Okay, so I looked at your, I assume this is the one that's set for today because it's what's listed by the clerks. It doesn't it doesn't attach the actual request that you're asking me to rule on, and so I'm not sure exactly what you want me to rule on.
We had to end up refiling with the exhibits, which was done, I think, last week, and then we also sent a paper copy up to your chambers with the actual requests.
What day did you send that? Was that on the 10th?
We sent, it was refiled and sent up there, yeah, on Wednesday or Thursday of last week. I know that the paper copy was sent to your chambers on Thursday. I believe the refile was on Thursday as well. It might have been Wednesday. Let me look.
I think I found it. Let's see. All right. Response?
Your Honor, I believe that as far as the facts are concerned, I think plaintiff's counsel said the facts correctly. A couple of things that are probably not necessarily, or she might not understand or have heard about. The request for production or responses do mention that Mr. Garuda had undergone surgery and was looking for documents, was unable to exactly verify responses at that time, but that all responsive documents, and not that we were withholding any documents, that all responsive documents were provided to Ms. Tomash prior to him going into federal custody. When Mr. Garuda got out of federal custody, he requested those documents back from Ms. Tomash. Ms. Tomash refused to provide those documents. Mr. Garuda attempted to log into to his company email and any company server that they've got. Ms. Tomash had locked him out of that and unable to get in and look for those documents. Ms. Tomash has responded has provided documents with her initial disclosures, and apparently Ms. Tomash has provided an affidavit saying that that's all that she had received from Mr. Garuda were those particular documents. So at this point, Mr. Garuda has recovered from his eye surgery and is attempting to look for more documents and supplement, which he's required to do.
Is he still in federal custody or is he out of it?
He is out of federal custody, Your Honor.
Okay.
And so since he's been out of federal custody, he's been attempting to get these documents. He has requested these documents from the third-party associates, mutual associates between himself and Ms. Tomash, which plaintiff's counsel mentioned. I don't know where we're at on that as far as getting the received. We'll obviously go through those and provide the responsive documents and supplementation. We as plaintiff's counsel mentioned, we did file a motion to compel from Ms. Tomash to provide documents, any sort of documents that she has. Her counsel has not responded at all to those documents, to those document requests, and in fact has stated to us that since they've settled, that he doesn't necessarily feel an obligation to answer those discovery requests, even though the Ms. Tomash is still a party to this case. We've also issued a subpoena as a belt and suspenders to get those documents. At this point, Judge, I think we're doing all that we can, at least from our perspective, to get those documents and provide responses to discovery. I don't know exactly what the court would compel in this case, other than just to compel Mr. Garuda to continue to look for documents and provide responsive documents, which he's required to do under the rules anyway.
I'm going to overrule all the objections that are made, order these documents to be produced within the next 30 days. And I mean, we'll go through the process. If he doesn't, he's going to need to you know how this works. Then they'll move for sanctions if you don't comply, then they'll move for contempt, all that kind of stuff. So this is just a way to try to get your client to make sure this is something that can actually do. So, but do let him know that he's facing right now a compel order, but it could get a lot worse. So to go ahead and get me an order on that, Ms. Boone, indicate that this that I've overruled all the objections, that the documents need to be produced within the next 30 days.
Will do. Thank you, Judge.
Just one other thing about the order. It'll need to say that this was heard on December 15th, 2025 over Zoom. All parties were present and it was on the record. give me a copy of that order by the end of the week.
Absolutely. Thank you, Judge. Will
All
do.
right. Anything else today, guys?
That's all I have.
Mr. Robinson,
That's all I have, Your Honor.
you guys have a great rest of your day.
Thank
Thank
you.
you. You too.
Mr. Heimer, what are you here for, sir?
I represent Shelly Tomash.
Oh, wait, you said you haven't been able to reach him. Okay. So do you have these documents?
I today she and I had a discussion, and she said that she produced what she had, but had a few emails that would be responsive to, or documents responsive to, one of those requests for production, like some of her phone records. But as far as the big Zoom recording and things like that Mr. Garuda took, she says those were recorded, but I don't know where they were put by Mr. Garuda, what password for it. Same thing with his emails. She doesn't have those either. So,
Well, you know how this works too. So I'm sure
yeah.
that Mr. Robinson is a good lawyer, and I'm sure he is. He's going to start pursuing your client to try to get those documents back, because now he has a deadline that he has to face, and that could mean
Well,
some.
and one thing I want to correct about Mr. Robinson's representation, we told him we settled, we're out of the case, we don't want to incur any attorney's fees, which is typically, in my experience of 35 years, the courtesy that most people give you when you're settled and you're not going to get paid. And I said she will voluntarily produce, even though she's an out-of-state non-party, voluntarily produce anything you ask her to produce. So that's why she's working on getting those discovery to her, so that, or she's going to answer those.
Okay, good. Well, Mr. Robinson, does that help you there?
Well, hopefully, I mean, if we get those documents, I mean, that'd be great. I mean, that's all I'm asking for is just whatever documents she can find and get. I think that Mr. Heimer suggested that they're going to do a deposition at some later date, and so at that point you can get the documents if you'd wish. To which I responded, I just want the documents. Your client was a party when they were issued and when they were due, still a party. I just give me what you've got, or if what she provided with her initial disclosures are responsive to all of our requests, just say that. I'm not really necessarily asking for much.
And honestly, Judge, I don't understand if these are materials Mr. Garuda provided to her already, why doesn't he just reproduce them to us? I don't understand why we have now, and we're dealing with this wasting policy. This may be the only money my clients see, since Mr. Garuda claims he has no insurance. Why doesn't he just produce to us everything he has, including what he already provided to Ms. Tomash? I just don't understand why we're going in circles when ultimately Mr. Garuda has the obligation to provide these documents.
And certainly, I mean, we can take the documents that were provided by Ms. Tomash in initial disclosures, rebates them, and send them back out. We certainly can do that.
But we know that that's not the universe of documents. It's not all the documents. We're entitled to everything.
When we will, and like I've said, and I think the judge has ordered, we'll produce those when we find those, and when Mr. Garuda comes across those, and if they come in, that's anything that's in addition to that, we'll certainly supplement those documents. But
okay. Well, I mean, the original requests were sent in August.
Counsel, we've got the documents that we got from Ms. Tomash in initial disclosures, and we'll rebase those and provide those. We'll also provide any sort of documents that we receive from mutual associates that are responsive to the request. We'll certainly provide those. We'll continue to look and comply with the rules, and we will absolutely certainly do that as the judges has ordered. So if the motion is well, I just don't believe Mr. Garuda, and if this is kind of like a liar pants on fire type motion, I don't know what else to show to the court or anybody else. We're providing what we've got.
I don't know. I haven't seen anything yet, so I have no idea if he's lying or not.
So I've done what I can do at this point. We can cross that bridge. I mean, Mr. Robinson is an experienced attorney, as is Mr. Heimer, and that if he doesn't comply with this order, then he's going to face sanctions and contempt. And if it turns out he's lying to me, he'll face the full responsibility that would be due him under, by the rules. So hopefully he will realize that and take these responsibilities very seriously. I will say that it does seem unlikely that he wouldn't have some type of records on computers or things like that he has access to if he was an owner of the company. But you know, we'll cross that bridge when we get there. I just kind of want to tell you my thoughts on it.
Thank you, Judge.
Thank you, Your Honor.
Give me that order by next Friday, okay? Or by the
I
end
will.
of the week. Thank you.
Thank you.
Thank you, Your
All right.
Honor.
You have a great rest of your day, guys.
Thanks. You too.